Abortion is all the rage in the news this week, but at least this time it's legally and politically, instead of violently in the way that's become fashionable lately.
Don't do that. Fucking terrible person.
Alabama has passed a law to criminalize the procedure in all cases but for when the life of the mother is at stake. Georgia, Missouri, Ohio, and other states have passed so-called heartbeat bills that generally criminalize abortion upon the detection of the fetal heartbeat. Louisiana has a bill nearly passed and supported by several Democrats in that state, including the governor. And additional states will likely follow in what is admittedly, at least in Alabama's case, an effort to get a challenge to the Roe v. Wade precedent before the Supreme Court, overturn that case, and return power to the states to regulate this issue for themselves. And of course, cue the stock progressive response to anything disagreeable. Women will die. Women will die. Don't you know women will die if the Supreme Court overturns Roe and power is returned to the states? Which is a weird thing to say, considering Roe has permitted the death of millions of prenatal women during its 50-year run, or at least millions of female clumps of cells, depending on what you believe, not to mention that women will die regardless. Death and taxes are unavoidable. Coincidentally, they are also the two main platforms of the Democratic Party. I kid, of course, but I do have a lot of frustration over how this Roe debate gets framed. Largely, we debate whether or not we like the result. If you consider yourself pro-choice, you think Roe was correctly decided because you like the so-called freedom to choose. If you consider yourself pro-life, you think Roe was wrongly decided because you think that freedom to choose is actually a freedom to kill. While I understand the passions behind these positions, and I'm not saying that they're wrong, I do think looking at the result is a poor way to evaluate the merits of a Supreme Court decision. Instead, we ought to look at the process, because the Supreme Court only has one job, and it's not to produce certain political outcomes. It is to uphold constitutional fidelity. It is simply to evaluate whether any law that is challenged before it is square with the Constitution or not. In the case of Roe, there are few decisions the court has ever made that are less faithful to its one job. This case simply invents rights into the Constitution that are not there in pursuit of a preferred political outcome. And on that basis, we should all embrace the overturning of Roe versus Wade, because it's a recipe for tyranny, not for freedom and autonomy. Let's walk through it. The Roe versus Wade decision overturned a Texas law that is very similar to the one that Alabama passed this week. It was a crime to provide an abortion in any case but for when the life of the mother is at stake. And the court declared that Texas law unconstitutional, null and void, and created the precedent that at least early-term abortion is a constitutional right that states cannot regulate. So how did they get there? After all, you will not find the word abortion or even any term tangentially related in the text of the Constitution. That's where the court had to get creative. Writing for the 7-2 majority, Justice Harry Blackmun concluded that an abortion is covered under a constitutional right to privacy. Though he grants that no such general privacy right is explicitly mentioned in the document, he writes it is implied in the concept of ordered liberty. It may be tough to make out, but if you focus really, really hard, you can see it right there in the penumbras of the Bill of Rights. If you're like me and you don't know what the hell a penumbra is, I googled it and found a very scientific diagram to help us understand. Here's a light source and an object casting a shadow. The penumbra is the lighter shading on the outer part of the shadow. So rethinking this diagram in constitutional terms, as the court did, here's the Constitution. It clearly defines enumerated rights. And then out here is your penumbra of shit that we like and we make up as we go along. And if you think that characterization is unfair, don't blame me. Blame Justice Blackmun, who writes much the same in his explanation. He doesn't even know where this so-called abortion-protecting right to privacy is. It might be in the 14th, it might be in the 9th, who knows? Look under the couch cushions. I saw it last week and I know it's there. How do I know? Because I feel that it's there. And what could go wrong with a bench of 9 unelecteds deciding national law based on subjective feelings? Feelings are not the basis for Supreme Court judgment. the Constitution is. Worse still, Blackmun and the rest of the justices encounter massive logical problems when they attempt to apply this invented right to privacy to the abortion context. Immediately after declaring this privacy right, Blackmun attempts to justify that declaration by writing, "Women denied abortion access may face hardship, distress, psychological harm, or other damage from caring for an unwanted child." But how is any of that relevant to privacy? If privacy is the issue, it doesn't matter if your pregnancy is easy or hard, only that it's private. And if hardship is the actual issue, can I just kill my kid the second he colors in crayon all over my walls? He's caused me anguish. He's caused me financial distress. He's caused me hardship. Doesn't that justify his killing? Of course, I'll end his life privately in accordance with my constitutional rights. I'm not a monster. Blackmun even acknowledges that this privacy right he's claiming is inherently different from privacy in any conventional sense, as it had previously been constitutionally applied to issues of marital intimacy, bedroom possession of obscenity, and other contexts. Why? Because there's another life at stake, a reality the court both acknowledges and denies based on whether it's convenient to the predetermined and preferred political outcome of the Roe v. Wade decision. Blackmun says he's unpersuaded by Roe's claim that there is no state interest in regulating abortion at all, that clearly the state has a compelling interest in protecting potential life. And he writes later that acknowledging the establishment of that personhood would, of course, collapse Roe's entire argument, since the fetus's right to life would be explicitly guaranteed by the 14th Amendment. However, Blackmun contradicts himself later. The definition of person in the Constitution does not include the unborn, he writes. If that's the case, there is no such thing as personhood in the womb, thus no compelling interest in protecting it. So to summarize, unrestricted abortion is not a constitutional right because the child's life is at stake. But also, there is no life at stake, so the right to privacy covers terminating that non-life. Yeah, I know it's confusing, but let's just move on and establish some extra legislative arbitrary compromise standard that says the first trimester is a free-for-all, an all-you-can-abort buffet. In the third trimester, the states can regulate. That's now the national insurmountable law of the land because we said so. So let's just call it a day and go home. And what we're left with is constitutional hocus pocus. Worse still, self-contradictory hocus pocus that says that the unborn are both life and not life, worth protecting and worth killing, and regardless of whether or not you like the rabbit pulled out of this nonsense hat, this is a standard that nobody should endorse. This is a standard of 9 unelected judges exerting arbitrary, outright made-up control of your life and life within your state based not on what the Constitution says, but based on what they feel it says, based on what they want it to say. That is a standard that is red hot and ready to burn you on a moment's notice, literally whenever they feel like it. Not just on abortion, but on any other issue on which the Constitution is silent that you should be able to control for yourself within your state. Which brings us to the solution, which itself is getting politically mischaracterized. Prominent defenders of Roe keep saying, this is a national fight. It's a national war on women.
We need to call this what it is: a nationwide assault on women's constitutional rights.
No, it isn't. Abortion is not a constitutional right in any sane and honest reading of the document. Therefore, the issue is up to the states to regulate for themselves, and these states are doing exactly that. Roe itself is the nationwide encroachment. Opponents of Roe want to be free to handle their state as they see fit. It's about states' rights, not national edict. Don't like what your state is doing? If the issue is that important to you, move to a different one. Move to California, which put this abortion-inclusive privacy right into its state constitution. Move to Virginia, where Ralph Northam will keep them comfortable before they die.
The infant would be delivered, the infant would be kept comfortable, and then a discussion would ensue between the physicians and the mother.
Move to New York, where the governor wants abortion rights in that state's constitution. Specifically New York City, where they're trying to make it free. Ironic, considering giving it away for free is most often how we end up in this mess, but the point is, that's the beauty of the federalist system. On these issues on which the Constitution is silent, it's up to you and your state to regulate it for yourself. It enables you to live in a locality that best reflects your values without imposing them on others, or at least leaving others the option not to be imposed upon by moving elsewhere. And that's the point. That is the value that Roe erodes that we rarely talk about, and understandably so. Abortion is one of the most morally contentious issues we confront as a country. But for all those people warning of forthcoming tyranny, forthcoming authoritarianism, forthcoming control of your life, no, it is the Roe versus Wade decision that does that. It is the Roe versus Wade decision that removes the autonomy of your state to decide this issue for itself. It is the Roe versus Wade decision that exerts arbitrary, top-down control, not based on any constitutional prescription, based only on the whims of old white men I otherwise often hear demonized. For every reason Roe defenders shill fear about its overturning, they should actually support it. Don't want a national culture war? Don't want men making decisions for women? Don't want top-down control? All of these fears are avoided and resolved by returning this issue to the states where it belongs, because the Constitution says nothing on this topic. Based on principle, these people and I should agree, but it's very hard to find their principles. Guess I'll just have to squint hard and stare into the penumbras for a while. I'm sure they're in there. Thanks as always for listening and for supporting this channel always. Appreciate that thoughtful discussion down below, and especially over on Twitter, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.